women's rights. She is a fellow of the Chan Institute of Arbitrators. That is our Honorable Lady Justice Ndung'u. I present to you, and we are delighted to listen to you. Honorable Lady Justice Njoki Ndung'u, you can make your presentation stand, or you are okay? Wherever, here or there? Okay, can we be upstanding to welcome our speaker? Thank you. Wow. Okay, okay.
Thank you very much. Good morning, everyone. I want to first apologize for being late. I went to the wrong campus. I'm very sorry about that. I'm normally a person who keeps good time, so I'm sorry that I delayed. And I think the principal has forgiven me. Yes, Madam Principal of this wonderful campus, the Dean of the Faculty of Law, the faculty members, members of staff, the students who are here present, ladies and gentlemen. Thank you for having me here today. It is my pleasure and privilege to be here before you on behalf of the Supreme Court of Kenya. In the Supreme Court of Kenya last year, we were celebrating Supreme Court at 12. We actually Supreme Court at 14 years, but we had started planning for it when we had turned 12 years old. And we had celebrations, including a lecture circuit by each of the judges to different campuses. We had the moot court where the students here performed very well, a moot court which I missed, but I heard accolades from my colleagues at the Supreme Court saying that the students were so amazing. And I wish to congratulate those students who took part. And we're really looking forward to seeing you back in our courtroom for another moot court sometime soon. I bring greetings from the President of the Supreme Court, the Honorable Chief Justice Martha Koome, the Deputy President of the Supreme Court, Honorable Philomena Mbete Mwilu, and my colleagues in order of seniority. We normally are very strict about seniority and precedence in our court. Justice Mohammed Ibrahim, Justice Smokin Wanjala, Justice Isaac Lenaola, and Justice William Ouko. All of them have sent greetings to you. I was with them in a meeting yesterday, and they sent their warmest greetings and saying they are all looking forward to coming to this campus as we continue our lecture circuit this year and in the years to come. It was interesting, Bernadine, that you'd mentioned that we are many women in the court. Actually, the initial court, it was quite a struggle. We were only 2 women in the inaugural Supreme Court in 2011. And now we have made progress to 3 women. But there will never be a time when we shall be all women, because the Constitution is very clear and says that all institutions, organs of state and government must have at least 1/3. So I think we can push for 1 more woman, but I think after that, then the balance will go on the other side. And really what we need to see is the equal opportunity for both men and women in this wonderful country of ours to participate both in public office and even within the private sector. Now, today when I was coming on my way, I realized that the manner in which I have written the paper, it looks like a paper for publication and not really a paper that would sit well in a lecture. And therefore, I'm not going to read word for word, but I will leave the paper with the Dean for it to be read later, but I'll just, just go over what the paper is about, which is really the Supreme Court and its jurisprudence on matters family law. However, I must give a short background before actually going into the case law of the court. Then there were certain things that were happening. Under customary law, ordinarily, before a man takes another wife, it was required that he would seek approval from that wife to take another wife. But in Kenya, where we had come to a place where we were in between, we were practicing African customary law, but we leave out some of the requirements, but we want to use some of the other requirements. Also, there were many marriages that were being arranged by parents for minors, girls who are underage, so it was quite chaotic. So the number of recommendations were made by this task force, which included the adoption of the Children's Act of 2001, the establishment of the National Commission on Gender and Development, and a number of recommendations which went into the Bomas draft constitution in 2004 after the Bomas conference, and which eventually resulted in provisions which are in our current constitution, the Constitution of Kenya 2010. There are also some progressions that were made from recommendations of that task force, which came into the Sexual Offences Act, and also the Employment Act that now provides for maternity leave. It had not before, paternity leave, and also protected men and women from sexual harassment in the office space, and allowed women the ability to return to work after childbirth, which had been a problem before the amendments to these laws were made. Now, we now have a omnibus Consolidated Marriage Act, which was passed in 2013. And still, there are a number of issues that are rising from it. And as I take you through the Supreme Court's jurisprudence on this, I will do it in subject areas so that you can understand which areas we were grappling with and which areas we have settled now in law. The first is the equal rights in marriage. The Constitution of Kenya recognizes the union of a man and woman based on their free consent, and Section 3 of the Marriage Act, which takes from the Constitution, sets out the features of a marriage as follows: that a marriage is a voluntary union of a man and woman, whether in a monogamous or polygamous union, and is registered in accordance with the Act. Parties to the marriage have equal rights and obligations at the time of the marriage, during the time of marriage, and at the dissolution of the marriage. All marriages under this Act have the same legal status, and it's only parties to an Islamic marriage where their rights will be granted under Islamic law. Otherwise, all other marriages and all other parties to a marriage have equal rights as provided by the Constitution. Apart from the issue of equal rights in marriage, the case I'm going to talk about shortly also talked about the distribution of matrimonial property. What is matrimonial property? It is the division of property in the event of a dissolution of marriage, and for them it is very controversial because the concerns have been to what extent, what is the proportion, how do we divide this property? And there's one school of thought that has said, when you dissolve a marriage, then the property must be divided 50. And they said that this is what the Constitution says. But there's another school of thought that says, no, what should happen is we should assess what a party has contributed to the marriage. And then you give it equitably, depending on the contribution one has made to the marriage. Of course, what is important is what is contribution. So there is direct contribution and indirect contribution. There's also monetary contribution and non-monetary contribution. So for example, you can have a couple, I'm giving you just a hypothetical example of husband and wife. The husband is employed in the formal sector. He has taken a mortgage for the house. The wife is a housewife. They have about 6 children. The children all have to go to school. They are all fed. The home has to be run. The court will take into consideration and has taken into consideration as a contribution even the factor of childbirth. Childbirth is also considered a contribution, and it can be assessed in terms of percentage, as well as the fact that the man used his salary to all contribute to the mortgage. So you can have Direct, monetary, non-monetary, all those contributions will be assessed by a court in terms of deciding how to divide matrimonial. So we have this matter that came in 2020, and I will call it JOO versus MBO. As you know, in family matters, we use abbreviations. We do not use the full names of the parties to ensure that they maintain the privacy of, some of cases, all the personal details come out. So in terms of how the lawyering is done, it's done that also the media are not allowed to carry names, and the parties have waived the right and have said that their names can be disclosed. So in this case, the appellant and respondent, the appellant was a gentleman and the respondent was the wife, were married under Abaguzi customary law in 1990. And in 1995, the union was formalized under the Marriage Act. During the process of the marriage, both of them acquired their matrimonial home in Embakasi, and they also constructed some rental units. The marriage then broke down, and it was dissolved. So they went to the High Court, and the High Court, using the principles in Sharia versus Sharia, which talks about contribution of each party, awarded the gentleman 30%. They awarded the wife 30% of her matrimonial home and 20% share of the rental units. She was aggrieved and went to the Court of Appeal. The Court of Appeal assessed her beneficial interest and gave them 50-50 equally. It then came to the Supreme Court. Now, in the Supreme Court, ordinarily, we would not listen to such a matter. Such a matter ought to just end at the Court of Appeal. However, they did raise the issue of equality under the Constitution, with the husband saying that the equality in the Constitution does not mean that the property is divided equally. So we made a decision in this. We did dismiss the circle. We upheld that the 50-50 distribution was the correct one. But we did say that the equality in Article 45 of the Constitution does not apply to matrimonial property. It applies to the rights that one has, but will not apply to matrimonial property, and that matrimonial property will be done on the basis of contribution, and it will be done case by case. So every case has its different way, contributions are different, so the courts below us have to each case by case and consider the contribution was made. In this particular case, we accepted that the 50 ratio had been done correctly. Another matter in which we considered the presumption of marriage. I think this is an interesting case because a lot of Kenyans do what we call come we stay marriages. People even used to call it marriage by affidavit. So when you're asked at work, are you married? You swear an affidavit and then you say, I'm married. But it's interesting now today because, in the days when presumption of marriage was recognized, in the case of Hortensia Wanjiko, that's a 1976 case that first recognized presumption of marriage. At that time, it was presumed that people who live together for a long time should be presumed to be married so that one party is not unfairly deprived of the rights and benefits that they should gain in marriage. But today, there is another come we stay. There is a come we stay of, we are staying together, but we don't want to be married. These young people here. So they don't want to be married, and they are very clear they do not want to be married. They don't want those rights and obligations and duties of a marriage, which would be under marriage law, but they want to live together. So that is different. But they'll be shocked. One of them can take the other to the court, and then the court says, you are married. We are presuming you are married. So we found ourselves in this situation where, let me read So in this case, the gentleman, and it was a very interesting case for this one for us because it's the gentleman who came to court and not the lady. Normally ladies come to court, but this time the laws have been skewed. So the gentleman comes to the High Court under the Married Women's Property Act. And he says he wants a division of matrimonial say that couples must have held themselves outside the world as being a married couple. What does that mean? Because in our culture, even if you are dating and you've stayed with each other for a couple of months, your neighbors will say, ni bwana nabi, ni bwana na bibi. That's the language we use. We don't know how to say boyfriend and girlfriend. So we are already presuming marriage, and yet these other things which have to be present are not there. So it will be very interesting to see whether in future we get a case like that where people say, but those people outside, our neighbors call us man and wife, but you're really not. You're really just people, two people living together. So that is what we found in that. We were able to say what presumption of marriage really is. We are also able to say that where you live together, but you're not married and you have acquired property, what then should be done? Right. Like I said, I'm not going to read the whole paper. It's quite lengthy. I want to now move to issue of children's rights, which has come to the Supreme Court. As you well know, that the Children's Act in Kenya, the Constitution of Kenya, the UN Convention on the Rights of the Child says that we must always put the child's interest first. But our Constitution also says that there is parental responsibility and parents should be also responsible for their children. And therefore, we had a case where we had to address the two competing interests, which is the best interest of the child and what are the rights of the parents and the responsibilities. And this is the case of MAK versus RMAA and four others, petition number 2 of 2022. In this matter, this was actually quite a convoluted matter. So, this couple get married. One is a Kenyan of Asian origin. One is a Kenyan of African origin. They get married under the... actually, they got married under the African Christian Marriage Act. Yeah, under the African Christian Marriage and Divorce Act. And they have a son. They later get divorced. They're still friendly to each other. And they set out a parental responsibility agreement. The mother of the child, then moves to the UK to study. She goes with the child. When she's in the UK, she disciplines her child. She takes a belt and she twangas him on the backside, like many African parents do. The child reports the mother to the father, the court, and give full custody to the father who is now living in Tanzania. Back to Kenya, and she tries to implement the parental responsibility agreement, which has been registered in the High Court in Kenya. The Tanzanian courts refuse to recognize it. The UK courts refuse to recognize the parental responsibility. Eventually, it comes to the High Court Kenya. The High Court Kenya find that, and all this time, the mother has not seen the child. They find that the mother should not see the child because she was cruel, and the UK courts found that she was cruel to her child, and therefore she should not see the child. It goes to the Court of Appeal. The Court of Appeal upholds the High Court. It comes to us. And we decide it's a constitutional question on the issue of parental responsibility, parental access to the child. And we had to determine a number of things. By this time, unfortunately, the child is already 18. This case started when the child was 9. Now, the child is 18. We did say, however, that we faulted the UK. There was no medical report that was taken to that judge. And the UK perhaps ought to have taken into the culture. What is the culture of the child where they are from? The discipline in our culture may not be the discipline in their culture. And that ought to have been considered since it was not, there was no medical report to say that the child had severe injuries. The mother had explained that she had used a belt to to beat the child on the buttock when he was naughty. So we felt that that ought to have been taken into consideration. But more importantly, the parental responsibility agreement that was registered in Kenya should have taken priority. It was the first registered. The child is a Kenyan child. The parents are Kenyans, and therefore that responsibility, that agreement should have been upheld by the courts. However, in balancing whether the child's best interests is to be protected and whether parents can access and what the rights are, we said the following guidelines should be noted. What a court will consider, they need to check whether there is an existing parental responsibility agreement. If there is, to say that the child should not contact the parent for whatever reason, if we find it is dangerous, then at least allow the child to be in touch with that parent's relatives. So the grandparents or somebody on the other side of the family should access the child. It cannot just be one parent. We also need to check the mental health of the parents and everything all together. So this is what we did in that case. And hopefully now, if we have court battles between estranged parents, the children do not have to suffer. That we have to immediately apply this so that as we balance the child's best interests, parents can also have access to their children and should not be denied access. We then said that this child is now 18. We cannot force him to go anywhere. If he wants to go and see his mom, he can go and see his mom, but we cannot direct him because he's now an adult. The final case that I'd like to just touch on in terms of family law was the case of CMM suing as next friend of and on behalf of CWN and 6 others versus Standard Group and 4 others. What had happened in this case? In this case, there was an incident of burning of schools, arson. And 4 students were arrested and they were charged in court. What happened is that the Nation Media Group, no, it was the Standard Group, then carried pictures of the children who are in court, televised them, and named them. So this case was one of the parents who came and said that this should not have happened. And after looking at the law, we did agree with him. And we did state that the following: that children are vulnerable and they must be protected, that criminal trials involving children should be held away from the public, and sensitive details should not be published. No photograph or description of the child should be published, even in a law report. And there should be a penalty if that happens. And we were able to award damages to the parent. And we are now very particular that the media cannot disclose a child's particulars, name, image, or disclose the child's identity. That is part of the rights of the children under the Constitution, and that was the conclusion of that case. In conclusion, only a few family cases actually reach the Supreme Court. Again, because it either have to be a GPI, a matter of general public interest, or it has to touch on the Constitution. However, even though we have made great strides in family reform, there are still a lot of problems that exist. And one of them that I'm very concerned about is the register of marriages. So you're supposed to get married and register your marriage. Whether you marry in church, at the Aegis chambers, or traditional, you're supposed to register your marriage within 6 months. First of all, I doubt if there's sufficient civic education. How many people out there, even now, even if I was to ask you, did you know you had to register your marriage within 6 months? How many customary marriages do all of you attend? And have you ever asked, or have you ever advised that you need to register for 6 months? But the problem with the registry, the register of marriages is this. Unlike the register of births and deaths, like now the register of births and deaths is now, it's in the office of the president under the immigration. They have now, they have embrace technology. It's digital. At one touch of a button, you can check your details, you can check everything. The marriage registry is still paper. Even if you are to register, you will not be able to find. Even if you're getting married and you want to find out if the person who you're getting married to is married already, you cannot find it. Because it is a mass of paper. So I think that something urgently needs to be done in the Attorney General's chambers to make sure that the Register of Marriages is working. Otherwise, we will continue to have a situation where people are marrying people who should not marry people. And people will find that they are not married because they did not register their marriages. And it will continue to haunt the courts and the public in general. So I want to just finish my presentation very shortly. The paper is much longer. So I invite you to read the paper after this, but I wanted to allow time for questions. And the questions do not need to be limited to family law. I'm open to answer questions on behalf of the Supreme Court to all of you. I thank you very much for giving me this time. Asanteni.
Thank you very much, Lady Justice Njoki Ndung'u, for that very informative discussion of the jurisprudence coming from the Supreme Court on family law. Now, we want to get into the second session, the question and answer session. And this session is going to be handled by Dr. Dennis Ndambo. Before I hand over the mic to Dr. Ndambo, maybe just one question. In the Law of Succession Act, there's a provision that says that when you have a succession proceedings in relation to the estate of, I think it is intestate succession where there's no will, in relation to the estate of a deceased person. I think it says the wife has only a life interest in the immovable property, that is, landed property. My question is, does that provision run afoul of the constitutional requirements on equality? Dr. Ndambo, please.
Thank you very much, Lady Justice Njoki Ndung'u, for the lecture that you've just delivered. All protocols observed. I would like to open this session for question and answers and any comments. Thank you so much, Dr. Ashers, for starting us off. Dean, if I may check with you, Principal at 20 minutes. I don't know how you feel. It's okay? Okay, we have her for the day. Okay, so thank you, Dr. Ashers has started us off. I propose we take about 5 questions so that she notes them down at first and then answers them, and then we can take a few more after that. So I hope, my lady, you've taken note of Dr. Ashers' question. Let me also hijack and also throw in one or two. First of all, I remember in campus, we used to have some sort of situationships, especially where there were hostels. So our female colleagues would assist their male colleagues with chores. Could be washing, their laundry, or cooking for them, while the boy was studying hard in class. So, and many a times upon graduation and after graduation, the boy would move on to his dream girl, a different girl, while this one who was assisting him is left, heartbroken. So I think this one doesn't quite fall in under come we stay and presumption of marriage. I don't know, maybe our students can tell us whether such situations still exist and whether it is a concern that we have that the law should address. Secondly, I hope I'm not moving too fast. Secondly, the other issue is looking at the combination of, marriages, the law on marriages, together now with the law of succession. You find that whereas we may say that this particular woman was not married to this man, or theoretically even, where there's a lady and has relationships with several men, they were not married to this woman, and so they didn't have a valid marriage. But when it comes to inheritance, in essence, this particular spouse who is claiming property is able to claim that property because they can show they were dependent, or even the child that they have is dependent. So then are we telling our ladies, and in this day and age, maybe to an extent, the men as well, all Kenyan marriages, irrespective of whether the certificate you have says it's a monogamous marriage, are actually just potentially polygamous, in essence? Because at the end of the day, the end if we say, in terms of inheritance, the end justifies the means, somebody will still inherit because of that connection. So then, should we be careful? Caveat before you get into marriage that in Kenya, it's actually they are potentially polygamous. Thank you. All right, so those are already 3 questions. Anybody who has a burning one? Thank you. I can see some, and here 2. Okay, so let me take this, and Joseph. Let me take those 3 first. Media, sorry if we are going to give you a headache. We can pass the mic. So please stand up, speak clearly, and be concise. Thank you.
Good afternoon. Okay, my name is Samuel Kahura. I have 2 brief questions. The first one is on the relationship between international law and domestic law in Kenya.
Sorry, Sam, just check if the mic is on.
It's on.
It is on.
Yeah. Okay, with regard to the Mitubel case, in Mitubel, the court decided that Article 2.5 and Article 2.6 does not automatically mean that international law applies in Kenya. The court sort of ran away from the question and said we have not shifted from the dualist position. So is that the case when Article 2.6 is clear that treaties apply directly once they are ratified? Then my second question is, some time ago, a scholar by the name Joshua Nyawa wrote a critique of the Supreme Court with regard to departure. So I want to pose the question, why does the court never explicitly spell out that it is departing from its earlier position, especially with regard to the Kibos judgment and Chaurembo? So why does the court never feel the need to say explicitly that we are departing from our earlier decision? Thank you.
Thank you, Sam. You are really putting my lady on the spot, but I'm sure she's up to the task. Next.
Okay, so my name is Anthony Akolo. I have a question in regards to the case that the court was invited to look on whether parties that have cohabited actually, what is the way of dividing the matrimonial property. And when I was reading the judgment in paragraph 33, the court agreed with Lord Boris on the fact that the Married Women Property Act that was appealed by the Matrimonial Property Act took into consideration marriages that were contracted even through cohabitation and so on. And the court stated in paragraph 35 that they are of the view that the matter of discussion is not how you arrived to the marriage, but in earlier decisions, that is the JWN versus M&W, the court had already seen the legal lacuna, and the judge went on to say that it is a high time that we come up with a legislation on how parties that have cohabited will have the matrimonial property divided. The court was of the similar view, but I come to realize that judges will identify the legal lacuna that is there, but is there any follow-up on whether the parliament will come up with a legislation on the same? Because if you look at the legislations that are currently in parliament, you realize that there's no legislation that has been tabled to take into consideration what the judge said. And this is not only the case, but if you also look at the Moses Dola Otieno case, you realize that the judge said that the parliament ought to come up with a legislation, but up to date, no legislation is in place. Is it a high time that we come up with a framework on the same?
Thank you. Francis, just behind you.
Yes, good afternoon. Your Ladyship, my name is Joseph, Francis Joseph, and my question, I have two questions. One that will build on the question asked by my lecturer, Dr. Ndambo, that the scenario that is here, he has given about the situationships in campus. And so the question would be on breach of promise to marry. Do we have to give back, or do we have to pay for the contributions that our counterparts have had on our lives? Then, Your Ladyship, the second question relates to the MAK against RMA case, where it was a jurisprudential moment, using the words that you like using, a jurisprudential moment, where the court had to set out the guidelines to be followed when you're talking about balancing the rights of the parties to the marriage and the best interest of the child. And we have this, one of the guidelines being the opinion of the child. Now, with respect to that, when you're looking at opinion of the child, and to some extent, when we talk of the opinion, it's sort of asking them to consent whether they want to go with the mother or the father. So, and again, being that you are the mover of the Sexual Offences Act, and one decision that has become very controversial is Justice Chitombo's decision on matters consent by a child in sexual matters. So I would ask, are we ready as a country to lower the age of consent? Because even as we're talking about opinion, to some extent speaks to consent of the child. Yeah, thank you.
I said. Thank you very much. I hope you can see me. Dr. Asha, indeed, I agree with you. Article 27 of the Constitution is very clear. There can be no discrimination based on sex or gender. And that, in my opinion, that provision in succession, where the wife has only a life interest, is clearly discriminatory. However, courts can only make decisions when they are moved. And I don't think that anyone has yet moved a court on this issue. I encourage you, in fact, you can come and move it yourself, because now you can even come on behalf of others under Article 22. So please, somebody out there, bring this to court, and we can have a definitive decision on it. On the issue of situationships, I think we need to hear from the situationship providers. on what they mean and how they intend it to be. I don't think the law can manage relationships outside of marriage and outside of a contractual relationship, like, for example, where you have bought property or where you own property. Love is not property. So I don't know how to manage situationships. But I'd be willing to hear what your thoughts are on this. On the law of succession, yes, I think the Kenyan situation is interesting. It's not like the UK or the US, where we do have a dichotomy of the types of marriages we have, monogamous and polygamous. I think the important thing is to be able to register, but I think Kenyans still, we've not understood the different definitions. For example, look what we do all the time. We always have a customary law marriage, which is potentially polygamous, and then we go to church, which is monogamous. So which marriage have you contracted? And have you understood the implications of the marriage you have contracted? That if it's monogamous, it means you can only be married to one person. And if it's potentially polygamous, you can be married to more than one person. Again, I don't know whether the public education, civic education is done among our citizenry for them to understand how to engage, and that marriage is a contract. I keep on saying this, marriage is not about love. Marriage is not about romance. Marriage is a legal and financial arrangement that you get into, and that's why when you divorce, the legal and financial implications are there. It's very different from a relationship, which is not a marriage. When you're not in a marriage, those things, if you're in a situationship, there's no legal or financial implication. But once you sign the register, once you commit yourself in marriage, then there's more. It's not just a commitment to love or partnership. There's a legal and financial commitment that you're making, and it has obligations and responsibilities. So that is different. However, separate a case is dependence. The Constitution is very clear that every parent is responsible for their child. So you cannot have a situation where children are disinherited, and the courts have made it very clear. So you may choose to have children with somebody else. That person may not inherit from you, but your child with that person must inherit from you, and that child can go to court and claim. What I think, and for you as young lawyers, as you go into marriage, I think people need to think about this being a financial and legal situation, and people need to start thinking about whether they need to register their own properties, register joint properties, register, do a will, distribute your property before you die, and then you can distribute to all your children, even the ones who are not in your marriage. I don't know why people wait. It's as if they're like, let me not divide, let me die first. And then there's chaos everywhere. Because nobody else is going to see your will except your lawyer. Just divide the property so that it is clear what your wishes are. And then we can avoid all this. We're always seeing it. Okay, now I see people have stopped. Before they used to go and stop the burial. Now I think they know that the burial has nothing to do with the case. So I think we see less of that, but I think it's distressful for the families involved and children. So I think, since you talked about men, I think men need to be responsible, but I also think women need to be responsible. I think if I had a few husbands, I would make provision before I die. But I'm not allowed to. Yeah, which is actually, it was an interest when we were discussing the case I was talking about, presumption of marriage, and we were debating because in the Supreme Court we have conference and we debate. And at first we were debating, like, this man, he's the husband of this lady. And then I told one of the judges, actually, why don't we just say he's the husband of this lady? Then women can have more than one husband. It changed the discussion immediately. But anyway, that I've said that in jest. On Chitembwe, I have criticized Chitembwe from the time that judgment was issued. I think we need to have an understanding about age of consent. What is age of consent under the law in Kenya? The Constitution is clear that you are an adult, you're a child if you're under 18. The Children's Act is clear. You're a child if you're under 18. You cannot vote when you're under 18. You cannot get a driving license when you're under 18. So what is this that we think that we can have certain things when we're under 18 and then we can become an adult? I criticize Chitembwe because Chitembwe actually said that this 14-year-old girl, because of her behavior, behaved like an adult and therefore she's an adult. I'm like, I even asked him, I said, Judge, you are now amending the Constitution, you are amending the Children's Act all by yourself in a judgment. How can that be possible? So I think what we need to do is to have a little bit more education about consent. What is consent? How is it given? And how do we educate, especially our boys, about the issue of consent? Parents educate their girls a lot about sex, about not to have sex, about what age to have sex, about the outcomes of having sex, something we don't tell boys. And then because we don't tell them, they get into these situations. But you know what we say, ignorance of the law is no defense. So we cannot say, and I had, this is my pet subject, by the way, so I can go on about age of consent. Because I had a big debate with CJ Maraga about this. Because CJ Maraga stood on a podium and he said that there are so many young boys and young men who are being jailed under the Sexual Offences Act. And I took him up on it. I went to prisons and I checked. There is no prison that has a male prisoner under the age of 18. All the offenders who are under the age of 18 are taken to Boston institutions. If you are under 18, you cannot serve a sentence of more than 3 years. The minimum sentences apply to you after you are an adult, 18. So some of the messages that are going out there around, and you know, I think as lawyers, we should not use terms that are not legal. There is nothing like boy in the law. When you say our boys are being jailed, there is no boy. What is a boy? There is a child and an adult. There is nothing like young men. It is not a definition. And if you go to our prisons actually, the prison population, the most criminals, whether it's theft, murder, robbery, sexual offenses, are between the ages of 18 and 25. It's not just sexual offenses. So I really, appeal that we talk about this subject without emotion, using legal language, but most importantly, that we give education around consent to our children. Because if you can tell your child, if you drive without a license, you'll be jailed. If you pick a knife and stab somebody, you'll be jailed. If you commit a crime, you'll be jailed. And yet we don't tell them, if you have sex without the consent of a girl, you will be jailed. We have to be able to tell them, because that is part of prevention, awareness of what the law is. So it is not Njoki Ndung'u who is jailing young boys. It is a law that was passed by a parliament. By the way, a parliament which had very few women that passed that law. A lot of people say I passed the law. I didn't. I made the proposal, but the law was passed by members of parliament, most of whom who are men. So like I said, it's my pet subject. I think you can allow me to come another time to talk just about the Sexual Offences Act. There's one question that was asked, I missed it, sorry, about parliament. Actually, in courts, we do often point and recommend within the body of our judgments areas that parliament need to address. For example, in Murwatetu, we clearly told parliament that they need to set out the parameters of what a life sentence is We also told them that they need to cure the anomaly around the mandatory death penalty for robbery with violence. None of those have been done to date. But as judges, we cannot legislate. So we find ourselves with a lacuna in the law, but a lacuna that the courts themselves cannot resolve. What do we do? So I think that we need to be more engaged with our members of parliament. You know, for a long time, I've been wondering, in Kenya, every 5 years, we go to the ballot box and we vote for our members of parliament. And when is the next time we see them? When they're coming back for the vote or to replace them. In those 5 years, they are legislators. They are looking at acts of parliament, which I believe they should be bringing back to their constituency. They should have a constituency day. We see out there, finance bill, whatever, those have been discussed at the constituency level, so that by the time the member of parliament is going on the floor of the house, they're actually carrying the views of their constituents. So I think there is a gap between the time that you vote for your MP and how do you assist your MP? Because that MP's voice is your voice. And things like this, you should be able to approach your MP and say, listen, there is a lacuna in the law. Why can't you be the member of parliament to move this amendment to the law? But I think we sit waiting for somebody to do something, but then it's never done. So that's my challenge to you. Challenge your member of parliament. Tell him you've seen that there are these recommendations which have been made by courts. There is this lacuna in the law. Let your member of parliament be that voice, or better still, run for member of parliament in the next election and take up this. Because really, the main role of members of parliament is to legislate, to lawmake. So I think you need to be the eyes and ears in your constituency, on your member of parliament, so that they're able to enact this law. There was one last question I missed here. Yes, about departure. I've just gone back there. I don't know how I missed that. It's here. There was the one on Mitbell, and how do we approach international law? Now, if you look at the wording of the Constitution carefully, we have a hierarchy of laws. There's the Constitution that comes first, and then the laws of Kenya. The international laws are not above the Constitution, and they are not above the laws. And therefore, if there is a provision under Kenyan law, we will look at the Kenyan law first before we look at an international provision. They can complement one another, but there has to be that hierarchy. That we are a sovereign state, and what comes first is what we have, and then where we need to borrow, we then go to our treaties or international law. I think this is a discussion we can have after this, and I suggest Justice Lenaula would love to have this discussion with you. He's the one who loves to debate this particular issue, but I wouldn't mind also engaging with you later. Does the court depart from its judgments? It does. We're the only court by constitution that is allowed to depart. Do we have to say we are departing? I think it might be a good practice, but it depends. Some of these cases where we have been told we have departed, we haven't actually departed. Actually, we are able to distinguish the circumstances and facts of that case from another. So I think it's important, like you, and I've seen you do, to read all the judgments and all the particulars and see whether actually they're the same or one can be distinguished from another. But I do take that as good advice, and I will let my colleagues know that that is a concern, and where we do depart, that we should actually set out a statement to state that we are departing from that. It would also help us as a court. As we are growing, we have to be very careful that our judgments are consistent. And sometimes because of the institutional memory, judges are leaving, judges are coming, we might miss that point. And if you think that there is a particular one where we made a mistake, please point it out. We are a court that listens, and we are a court that would correct a mistake if the mistake exists. Thank you. I don't know if I've covered everything. You're covered.
Thank you very much, my lady. Now, may I open it up to ladies? Let me be specific to ladies. Wow. Okay. This one is very difficult. You will guide me. Okay, let me start one. Mwalimu, two. Maureen, please forgive me. That's four. And five. And six. It's a comment. Okay. Yeah. So one, two, 3, 4, 5. Okay. Just hang, please be patient. Yeah. Is this the same mic? There was another mic.
One. Okay. Thank you. Thank you for the opportunity, Your Honor. My questions are 3 and they are brief ones. The first one is when you're reading the Children's Act, Cap 141, there's a provision that the court cannot grant adoption to a male person, just as a male. I am against it, and because the court interprets what the legislature does, I'd like to ask for your view on the same, because you interpret laws. Why can't we have a male adopt a child? I feel like that's discrimination based on gender, because I believe there are males that were raised properly that are able to raise a child. And my second question is, what's the legal framework for step-parent adoption in Kenya? I've been trying to find that online, and they are giving many provisions, but they're not pointing out particular sections of the Children's Act. I've gone through the Act myself, and there is no place it mentions explicitly step-parent adoption. So is it a matter of inferring from the law when it comes to step-parent adoption in Kenya? And my third question is the case you were telling us about, sorry, the second question. I'm saying step-parent adoption in Kenya. Yes, step-parent adoption. Is there a legal framework? Because in the Act, there's no place they mention a step-parent. And the only near thing is when one of the spouses is applying, then we need consent from the other spouse. So can we infer and say that is step-parent adoption in Kenya? And my third question is, you were telling us about presumption of marriage. I'm kindly asking if you could tell us the year of that case, because there was another case I read, JPO versus AP, and the judge was, it was a case between a marriage that had lasted 20 years. It was customary, but the judge was also talking about it as presumption of marriage, but the couple could not get a divorce because that marriage was not recognized in the first place. So presumption of marriage, why are we still discussing presumption of marriage? Is it because of succession, or, I don't know if you get my question.
Okay. Thank you. Let me ask the decision that you just mentioned, JPO, was it High Court, Court of Appeal, or?
It was Court of Appeal.
Okay.
Yes.
All right. Thank you. Now, please kindly just, stick to one question. All right. Please, just one question. Okay. Please pass the mic this way.
Mine was it's one question. It's about prenuptial agreement, whether they're still applicable in Kenya or just the general law. So long as you've bought property outside of marriage, it remains yours even if you divorce.
Thank you. Quick, short, precise. Okay.
My name is Maureen Danu, and my question is matters jurisdiction. You earlier stated that you usually deal with, among other things, matters are of general public importance, and it's also highlighted in the Constitution pursuant to Article 163 4B. Now, my question is, general public importance, it's a bit general and a bit broad in nature. So where is the line, the cut, or particular test that you guys tend to use in determining such particular matters, that it's actually a matter that is of general public importance or not? Thank you.
My Ladyship, my name is Nicole, and my question is concerning the position of customary law in family jurisprudence. So, in this day and age, with our cultural diversity as a country, there's a lot of inter-ethnic marriages and all that, and that may be raised during these proceedings. So my question is, how does judiciary navigate the intersection between customary law and constitutional principles, especially when cultural practices appear to conflict with fundamental rights, and also considering the factors of evolution of customary marriage, and considering that we do not want to erode our cultural identity as a country? Thank you.
Thank you.
Thank you very much. My name is Anne Mwendwa from the University of Nairobi. My question relates to marital rape. So this has been a matter that we've been talking about for a long time, right? So given that it has not been recognized in the Sexual Offences Act or any other Kenyan law, to what extent does this legal lacuna undermine the rights of these married persons, and especially their human right to dignity?
Okay, sorry, maybe just repeat, start again. I think she missed the beginning.
Okay, so my question relates to marital rape. So to what extent does a legal lacuna undermine the rights of married persons and their human rights, especially those rights to human dignity and against violence, and to what extent is this being addressed? Thank you.
Thank you. Pass it to the front.
Good afternoon, everyone. My Ladyship, my name is Grace Kaki. My question is on the presumption of marriage, especially cohabitation among young people, when there is the fact of the child. My question will be, according to the best interest of the child versus the parental responsibility, will it be the parents who will be in charge of the child or the grandparents, considering the grandparents are basically sponsoring the parents themselves? And especially, I think it's true. Yeah, so if the grandparent says you're not raising the child right, will she have the more power than the parent herself? Thank you.
Okay, thank you very much, my lady. We were very inspired by your CV and your serious commitment to social justice, which you have followed up through Parliament, before Parliament, and now at the Supreme Court. Mine is a comment, it's not a question. I am very happy with the findings of the Supreme Court when it comes to issues of marriage and balancing, because the law cannot solve all socio-cultural problems. And when you were talking, I was thinking about my village. There are very few people who are legally married in my village. Yet they have been very married for many, many years, including my parents, 50 years. But they're not legally married. So if the highest court was to sit and just say, because I've seen the courts, especially the other courts, have become a bit very rigid when it comes to presumption of marriage. Then we'll end up having a very big problem in the society. So even as we make law in courts, let's mediate with socio-cultural realities of our society. And that's very good when the court says, you're not married, but then we infer trust so that there is gender equity and equality when it comes to managing the properties and all that. So thank you very much and for the honor of being here.
One comment, then you can now respond to all of them. Thank you, Madam Wahu. When I joined the practice of law behind her, she's my senior, whenever we did divorce cases, there was a decree, nisi, followed by a decree, absolute. So there was what is called a cooling off period. 2 years had to go before you can go back for a decree, absolute. But beginning 2014, we have seen a new trend where judges are saying there is no need of keeping these people married when they are not in love, when they are not married. So what informed this decision of changing, the trend, cooling off period to this other one of immediate dissolution of a marriage? That's one. And number two, as students at the University of Nairobi, and I know in all these other universities, there are places where people go to pledge loyalty. And for us at the University of Nairobi, the late justice was there. It was box. It was box. Now, what happens to these children born out of these fellows who are actually cohabiting? They're basically cohabiting. And of course, quite a number of fellows are sent to exile. I'm sure the late justice understands. People are sent to exile, but ultimately, the truth comes out in form of children. What is the legal status of these children? And how do we deal with this kind of people whenever this issue arises? Because they will not even end up marrying each other, but they have a child. And I think we have done, let's finish. We'll invite the judge to come another day. I'm sure she'll be willing to come.
Thank you. On the last question, let me just start there about the children. The Constitution is very clear that children have rights. And one of the rights that they have is to parental care and protection, which includes equal responsibility between the mother and the father. So we have sufficient case law now where people have come to court and the errant father or mother now has to provide under this clause. The parents must provide equally for the child. The grandparents are not involved, let me just say that. And I think in the first place, because they were not there when the child was being conceived, so it is not their child to look after, but it is the parents of that child who the court would find responsible for that. Sorry? Can you hear me now? Is that better? Okay. So I just wanted to make an observation, though, which is interesting, that most of the men who have asked questions have asked questions about the court and the decisions of the court, and the women are asking questions on family law. I'm just wondering whether it's a question of priority or what affects the other most. When you come to adoption, it is true that the law says that male persons cannot adopt. Again, this is a decision of Parliament. Again, anyone can come to court and challenge it and ask the court to determine whether Article 27 is not being violated. But I don't think that has happened. A step-parent would go through the same adoption process that is laid out in the Adoption Act. The adoption process in Kenya are very detailed. So I think the step-parent would have to do that. Actually, there was even a time when the law said that if you are a woman, you also could not adopt a boy. Or if you are a single woman, you could not adopt a boy. You had to be a married couple to adopt a boy. And as a result, there are a lot more boys in children's homes than girls. Because, it's as if you're encouraged to, it's easier to adopt girls than to adopt boys. So I think that this is a serious, an area which needs to be followed up on, and it's actually kind of sad that boys are not adopted as much. On the presumption of marriage, you asked me, the court case that we determined was recent. It is MNK versus POM. It is petition number 9, Supreme Court petition number 9 of 2021. So you might find that there are other courts who have made determinations before we made this determination or are unaware of our decision. But from the date of this decision, the courts have to follow the presumption of marriage that we have laid down in the guidelines. All courts are bound by the Supreme Court decisions, and therefore they must follow these guidelines. Prenuptial agreement, it is not provided for in the law. However, it's a good idea. I always tell people, before you get married, if you have sufficient property you feel you ought to protect, or if you want to make sure that your partner is not interested in your property, it's always a good idea. But it's not, you won't find it in a law. But if you are to bring a prenuptial agreement to the court will recognize it as a contract between two people. When you get married, the property that you own before you got married is yours. The property that you acquired during the existence of the marriage is ours. So, and how you contribute will be how it will be divided. But I would advise a prenup if you think you have sufficient assets that you wish to protect. For the GPI, I think this must have been in 2013. There is a case called Malcolm Bell. I don't have the exact citation, but in that case, it was, I think, Malcolm Bell versus Daniel Arap Moi. We set out the guidelines of which cases will qualify to be GPI. And some of the guidelines include that the issue that is being raised, the point of law, is one that will affect not just the case before us, but it will affect the general public. So we will not take your case if, looking at that case, it will only be a benefit to the party. But if it's a benefit to users, to consumers, you are able to show us that if you make a decision in this matter, it will affect an industry, then we will take it. Take an individual case where we believe that the guidelines in Malcolm Bell, and I ask you to look at them, if maybe you can find them for me and I can read them out. Malcolm Bell, the court, we are very strict. We are very, very strict. Very many cases come to the Supreme Court. And we have filters because we cannot listen to all cases. Some cases must end at the Court of Appeal. The Supreme Court, our jurisdiction is limited. I'm sure you're aware of our jurisdiction. So we have original jurisdiction in presidential petition. We have original jurisdiction where a judge has been removed from a tribunal. They can come on appeal to us. We have original jurisdiction to listen to an advisory opinion where a state organ is seeking advice about another state organ. We can listen to appeals, but the only appeals we listen to are the ones that touch on the constitutional interpretation and application of the Constitution, or it's a GPI, and a GPI must be certified. So you must get leave of the Court of Appeal or the Supreme Court for us to listen to your GPI. We won't listen to your GPI just like that. We also, I think we have one jurisdiction we have not invoked, and that is the state of emergency, that if the president is to declare a state of emergency and there is a challenge to it, that it comes directly to the Supreme Court. So the Supreme Court, we have these jurisdictions, but we don't listen to everything. So GPI, we restrict, we don't listen to everything. On the issue of interethnic marriages and customary law, please look at Article 159. In particular, if you look at 159, subsection 160, subsection 3, in which we cannot give justice where, even if it's a traditional provision or mechanism, if it's repugnant to justice. And repugnant to justice would be against the Constitution, against Article 27, against that takes care of discrimination. So a court of law, even when applying the principles of a customary marriage, will have to look and see whether it is in violation of the Constitution. Marital rape. Now, I don't know, how old were you in 2006? Please don't tell me. Tell me at least you were born, or not yet. So in 2006, I moved the bill, the sexual offences bill, on the floor of the House of the National Assembly. And in that bill, there was no exclusion. However, as you know, when a bill goes to Parliament, it goes to the committee stage, it has to go to the debate stage. As I told you, I was sitting in a house where of 224 members of Parliament that time, there were only 18 women in Parliament, majority were men. This issue of marital rape, they could not allow it to pass. And they brought in the exception. Now, can that exception be challenged in court? Probably. But again, somebody would have to come and move the court and challenge it as discriminatory. But until that is done, marriage remains the one exclusion in the Sexual Offences Act. When you look at the provisions on consent, it says that the provisions relating to consent do not apply to persons who are married. So that is the unfortunate situation that there is relating to marital law. Why is it that the courts are moving so fast nowadays on matters of divorce? It is because of the New Marriage Act. Before the New Marriage Act, you could only get divorced on 4 grounds: adultery, cruelty, desertion, or insanity. All of which means you are accusing somebody, and that's why divorce was very ugly. People were reluctant to go and divorce because you have to accuse somebody of doing or being one of those 4 things. And so people were very reluctant, courts were also reluctant, it was very messy. But the New Marriage Act has brought a ground of irretrievably broken down, that we are no longer able to get on. You don't have to say why. And because of that, now it's just easier. You don't have to come and ask divorce. If it's adultery, then you have to serve the person who is committing adultery. Then you have, there was so much. But nowadays, if you don't get on, you come to the court and say, this marriage is dead, it can't work, then you get the divorce. So the law has made it easier. I don't know if I've answered all the questions. Have I? Is there anything that I've left out? Thank you very much.
Let's appreciate the judge. Because of time, and in order for us to, to have a date, so that we can invite her again, I'll request that we wind up the session here. Let me invite Madam Hannah to give a vote of thanks. Then you'll wait for a minute. I'll make an announcement. We have a closing prayer. Then we'll go out there for a picture session.
Thank you very much, Dean. I can say that this session was super, super awesome. Thank you for the lively discussions. As we had agreed with some of you, hamkutuangusha. Yeah, we are really challenged, and as we always say, we are always ready to learn from each other. The lecturers do not monopolize the knowledge, and as you can see, the judiciary through the Supreme Court has joined us in the arena of, developing knowledge. A few things got me, and of course, you always think that you know, but we don't know. The trust relationship vis-a-vis the presumption of marriage. That's a major thing to note. Like you can actually, like the guy, you can tell yourself that you're in a marriage, kumbe. The lady, you've heard the facts. I think that's something which is very notable. Of course, it can apply vice versa. Then it had not hit me that the act of birth is an actual contribution. Yeah, I saw some of the gentlemen smiling very hard. So as ladies, we really feel appreciated there. And what I can tell you, Lady Justice, these discussions, they have just started. This will enrich the research that is being, I can already see the research topics on presumption of marriage, trust relationship vis-a-vis all those issues which have been discussed here. The issue of the life, intestate interests, so many live issues. Challenges have also been thrown to us. The legal lacunas which you are talking about, indeed, as a law school, we have a major role in, addressing these lacunas. We have legal aid, clinics, groups, and clubs. You can move parliament, you can move the court. There's so much we can do to influence policy, to do what is supposed to do, so that, we become part of the active justice system. Then, especially the issue which was highlighted on the register of marriages. A while back, I worked at state law office, and I can confirm to you that, yeah, it can be really chaotic when you're dealing with paperwork. You can imagine when this country started registering marriages, how then can you be able to ascertain that the person you want to marry or the person you want to get married to is not already married to another person? I think we can talk these issues even in our social media, and one way or the other, things can start happening. I've been given the opportunity to give a vote of thanks. Thank you so much for your participation. It was a pleasure, indeed, Judge, to listen to your discussion on the judicial philosophy that underpins family law in the Supreme Court. Many thanks to the judiciary team. I can say it's a whole machinery. We are honored to interact with you. And of course, we look forward to further engagements with the judiciary. And indeed, we've been assured that this is only the beginning. And we also wish to thank the staff, the academic staff, the non-academic staff from other departments. We feel the warmth when we are together here. Thank you for the organizers of this event, both the judiciary team and the administration team together with the School of Law. We look forward to more and more engagements. Thank you.
Let me turn the mic back to our Lady Justice to make closing remarks.
Thank you very much. Before I just make some remarks, I had put up one of the cases in which we have reiterated the test for GPI. So the first test is that whether the case has a significant bearing on public interest. The other one will be whether in a point of law, whether it has a bearing on public interest. Then, of course, the questions must have always arisen first in the courts below us. You can't come to us directly. And they need to have been determined first before they come And I can't really read. Yeah, in case there is uncertainty, sometimes we get Court of Appeal decisions. Court of Appeal, two different benches have done two different judgments saying two different things on the same issue. So on that one, we would consider a GPI. What is the other one we would say? Anyway, the case law is here. I'll share with the Dean, and you can be able to see on what grounds you can come to us on a GPI. I just want to thank you very, very much for inviting me here. You know, judges, we only speak through judgment and also through formal engagements such as this. Unfortunately for us, we cannot engage on social media. Whatever comes our way on social media, we are unable to respond. We can only respond in a very restricted way. So it's always a delight and a pleasure to be able to come and engage and speak. We live very lonely lives. We live like hermits. And sometimes we like to engage, especially with young people, to hear what you think as well. We are not like this ivory tower that does not listen. We are there to serve the people of Kenya. We want to hear what ideas you have, where we need to be corrected. Judges are not judges are fallible. We're not infallible. So we also listen and we also hear. I really wish you well. Before me, I see many judges to come, many members of parliament, maybe many legal practitioners. And I hope that when you become officers of the court, you understand how to conduct yourself before the courts, how to embrace the professional ethics that you are to be taught in the law school and even in the School of Law. And, you know, I wish you all the very best, each one of you students, in as you go forward in your studies and in your careers as legal professionals. I want to thank the law school, the dean. Thank you very much, faculty. I'd love to come back if you will have me back. I can come on a different topic. I can see the topics are many. I also know that each one of my colleagues is also really keen to come to this campus, from the CJ to judge number 7. You know, that's how we fondly refer to each other, judge. So I am judge number 4. So we fondly refer to each other by numbers. Each one of them wants to come to this particular campus and to this school. So thank you very much for having us. Thank you very much, the principal, who I can see has left us, for hosting us. Thank you very much, the student leadership. I thank you very much.
Let's appreciate our guest. We have officially come to the end of the session, so I'll request that we rise, and then we'll have a student volunteer, a lady, come and pray. A student volunteer. Ndanu, please come. She's going to pray, but Justice has informed me they have a particular prayer. She'll close. She'll close. Yeah.
Okay, let's pray. Thank you, God, for this moment that you've given to us. Thank you for the event that we've just had right now, the meeting, the informative meeting that we've had. Thank you, Jesus, because we're living here wiser and better than we came in. And we know, Lord, that the few and the many that we've heard, we shall go out there and be able to practice them more and more in our career. And it is in Jesus' name we do pray and believe.
Justice is going to offer a short prayer. That clearly indicates that even as a court, they start with God and finish with God. They also rely on God. They're human. She will do that when she comes in next. Another. Oh, she can find. Yeah. She's going to
give the history. Yeah. So I just wanted to say in the Supreme Court, we have different traditions. Like the US Supreme Court, I don't know if you know that when they rise from their judgments, they go behind the curtain and they shake hands. Because sometimes when we are debating and our discussions, they can become quite fierce. We disagree, we don't agree. So sometimes it's good to have a tradition where it's like peace. We are like, okay, that case is finished. Now we move to the next one. So in the Supreme Court of Kenya, we actually developed a prayer for the court. And this prayer, we say it before we go into the courtroom. We also say it before, I found it, it's okay, I have it. We also say it before we go to conference, before we go to court, and when we leave court after a very difficult decision. So I wanted to share it with you so that you can get the sense and feeling of what the Supreme Court does and how it prays before we go into court. Almighty God, as we convene to perform our solemn duty, may wisdom and fairness guide our deliberations. Grant us knowledge and insight that we may uphold the truth and justice. Give us compassion and understanding to interpret the law with impartiality and integrity. And may our decisions reflect fairness and respect for the rights and dignity of all who come before us. May our efforts contribute to a just society where harmony and equality prevail, and where the protection of the law is accessible to every individual. In this pursuit of justice, we unite in the reverence of the rule of law and the promise of a better future for our nation. Amen. That is the Supreme Court prayer.
Thank you very much. We'll allow the Honorable Judge to leave the room. We'll hold on, then we'll take a picture outside the principal's office. So you'll join us there for a group picture after this. Thank you very much. May God bless you.